Well, good afternoon, ladies and gentlemen, and welcome to the Knowledge Congress webcast. So at this time, we're going to turn the conference over to Ms. Willis H. Schneider. Ms. Schneider, you will have 25 minutes to present. Should take you to about 33 minutes past the hour. So please go ahead and let's everyone please turn to page 13.
Okay, thank you very much, Paul. And I guess we can actually go to slide 14. I'm going to give sort of an overview, and some of the other speakers, will be filling in on certain of these points. But just first, kind of big picture. So what is FATCA, the Foreign Account Tax Compliance Act? It was enacted as part of the so-called HIRE Act back in 2010. And it was designed by Congress to police offshore investments, accounts, and trust interests that are held by U.S. persons. What they did was to basically put the burden for this on non-U.S. entities, and in that regard created quite a stir, which is one of the reasons why, as you'll see, they had to keep pushing the effective dates back to deal with various comments and let people get a handle on what they really had to do here. The IRS issued final and temporary regulations in January of 2013 and February of this year, which generally impose obligations on so-called foreign financial institutions, or FFIs, which you'll be hearing a lot, as well as certain other non-U.S. entities, to aid the IRS in monitoring U.S. accounts. And in addition, and in sort of a parallel development, the U.S. Treasury Department has entered into several so-called intergovernmental agreements, or IGAs, which provide FFIs that are covered by them with alternative approaches for complying with FATCA. And these agreements only cover FFIs as defined, which include in particular non-U.S. banks. FATCA is finally due to become effective, and as I mentioned, following a variety, a number of extensions, this July 1st. Next slide, please. An FFI basically includes a non-U.S. entity. We're on slide 15, thanks. An FFI includes a non-U.S. entity that accepts deposits in the ordinary course of a banking or similar business, holds a substantial portion of its business financial assets for the benefit of others, is a so-called investment entity, which includes funds, private equity and hedge funds, or is an insurance company, or a holding company or a treasury center, which meets certain requirements. So as mentioned, non-U.S. banks, definitely fall into the category of FFIs. Next slide. Just going to give an overview of the regulations, which I mentioned. Basically, under the regs, and which build on the statute, non-U.S. banks, and as well as certain other non-U.S. entities that fail to comply with the regulatory requirements generally are subject to a 30% withholding tax on certain withholdable payments that they received. So withholdable payments are U.S. source payments of so-called FATCA income, which is fixed and determinable annual and periodical, includes dividends, interest, rents, salaries, in this case made on or after July 1st of this year, as well as gross proceeds from the sale or other disposition of property that can produce this U.S. source dividends or interest. And here, FATCA kicks in with respect to sales occurring on or after January 1st, 2017. So there's a like 2.5-year lag period with respect to that. Next slide. The regulations require non-U.S. banks and other FFIs to register with the IRS as a so-called participating financial institution not covered by an IGA, and we'll get to the IGAs soon. Also to obtain a Global Intermediary Identification Number, or GIN, and to avoid the withholding, the non-U.S. bank will be required to provide withholding agents with a withholding certificate that includes this number. Typically, this will be provided on an IRS Form W-8 Ben-E. This is a new form which builds on the W-8 Ben, but includes a rather detailed set of provisions which require you to attest as to why you're in compliance with FATCA. And then the withholding agent, in turn, will be required to verify the bank's number or GIN against a list that will be published electronically and updated monthly by the IRS. And then the third thing is that the FFI must enter into an FFI agreement with the IRS. Next slide. So the next slide shows what the FFI agreement effectively requires. Under the agreement, a non-U.S. bank must identify its U.S. accounts, and as a cautionary note, U.S. accounts will include accounts that are held by non-U.S. entities if they have U.S. owners. So if you have a so-called substantial U.S. owner, you will be subject to treatment as a U.S. account, and therefore the non-U.S. bank has to identify it as a U.S. account. You have to report information about these U.S. accounts to the IRS, and if non-U.S. law prevents reporting, then the bank is required to obtain a waiver of such law from the account holder, or if not, to close the account. And I might add that anecdotally I've heard that some smaller non-U.S. banks in the wake of FATCA basically started taking the position that we just don't want any U.S. account holders. We don't want to deal with this. Obviously that's not the case for majority of the banks, and certainly the larger banks, but I have heard that. In addition, the bank must withhold on what's called a pass-through payment, a withholdable payment as described, or what's called a foreign pass-through payment, which is a payment attributable to a withholdable payment. And exactly how that's going to be determined remains to be further defined in future guidance that the IRS will come out with. And you must withhold on any such payments that are made to an FFI that's not in compliance with FATCA, the so-called non-participating FFI, or to account holders that fail to submit the proper information or fail to provide the waiver of non-U.S. law, or so-called recalcitrant account holders. And there are certain reporting requirements that also apply with respect to accounts held by non-participating FFIs and recalcitrant account holders, so in addition to the withholding. And finally, the FFI agreement requires the FFI to adopt a compliance program to satisfy the FATCA requirements under the authority of a responsible officer. This can be an officer who has or should be an officer who has the authority to undertake these responsibilities. That officer can delegate but remains liable. And I think Joe will be getting into this in more detail in his segment. So that's sort of an overview of the regs. We can go to slide 19. As I mentioned at the outset, in addition to the regs, there is sort of a parallel universe, if you will, of implementation of FATCA. Slide 19, please. And those are the so-called intergovernmental agreements, or IGAs. And an IGA, if you're under an IGA, then you comply under the IGA as opposed to under the regulatory regime. An IGA will cover an FFI that's resident in, or in certain circumstances organized under the laws of, the subject non-U.S. jurisdiction, but it doesn't apply to any branches of that FFI that are located outside that jurisdiction. So for an entity with multi-branches, this gets somewhat complicated. The IGA will also cover FFI branches located in the subject jurisdiction, even if the FFI is not resident in or organized under that jurisdiction. And typically, so again, non-U.S. banks are treated as FFIs under the IGAs. Now, the U.S. Next slide, please. The U.S. Came out with two versions of the IGA, which particular jurisdiction could choose between, and they're different because they require slightly different things of the FFIs that are covered by them. So under the so-called Model 1 IGA, a non-U.S. bank must register as a so-called registered deemed compliant financial institution and obtain the GIN. However, if you're covered by a Model 1 IGA, you are not required to enter into the FFI agreement, which I had just described. So these entities are not required to report information directly to the IRS. Instead, they will be required to report information about their U.S. accounts to their local governments under procedures prescribed under local law, and the local governments in turn will relay that information to the U.S. IRS. Non-U.S. governments, as we speak, are in various stages of enacting local legislation and regulations and other guidance implementing these FATCA-related requirements. And I would add just anecdotally, I mean, the Cayman Island, for example, earlier this month, they issued draft guidance on compliance requirements under the U.S. Cayman and U.S. UK IGAs, and this draft will be finalized June 6th. There's a comment period during which the IRS and the UK Inland Revenue are able to give comments. So apart from the Cayman Islands, other model IGA jurisdictions to date include Ireland, Israel, Canada, the UK, Germany, and France. Next slide.
And before we get to that, if I might just interrupt for a second here, it's time for secret word number one, attendees. Secret word number one is payment. P-A-Y-M-E-N-T, payment, is the first of the secret words, and you want to jot that down, so when you get your survey, you can fill in payment as secret word number one, and you will get your continuing education credit. So payment is secret word number one. Now let's get back to Ms. Schneider.
Okay, thanks. We're now on slide 21. The Model 2 IGA, again, the non-U.S. bank must register as a so-called reporting financial institution under a Model 2 IGA, so a different terminology, but also obtain a GIN. And the big difference between the Model 1 and the Model 2 is that a non-U.S. bank that's covered by a Model 2 is required to comply with the terms of an FFI agreement, so reporting directly to the IRS, although the FFI agreement may be modified by the Model 2 IGA, which covers a particular jurisdiction. And just as you see on the slide, Model 2 IGA jurisdictions include to date Japan, Switzerland, Austria, Chile, and Bermuda. Okay, next slide. I just wanted to touch on the concept of grandfathered obligations because payments made under so-called grandfathered obligations or payments of gross proceeds from the disposition of such obligations will not be subject to FATCA withholding when FATCA withholding goes into effect beginning July 1st or, as I mentioned, on the gross proceeds January 1st of 2017. Grandfathered obligations are debt instruments issued before July 1st of this year. And one cautionary note is that if a debt instrument is modified in a way that is treated as a so-called significant modification under the Section 1001 regulations, then the debt instrument is deemed reissued for U.S. tax purposes and including for this purpose, so it will no longer be treated as a grandfathered obligation. In addition, grandfathered obligations do not include legal agreements that are treated as equity for U.S. tax purposes or that lack a stated expiration or term. So it's really your garden variety debt instrument issued before July 1st and not modified thereafter in a significant way will qualify, and the payments on those obligations will not be subject to FATCA withholding. Next, on the next slide, We've listed here just on the next few slides some significant dates. May 5th, which obviously has already passed. This had been the last day for FFIs to register and obtain a GIN in order to be completely assured that they would not be subject to FATCA withholding. But for those who missed that, there's a June 3rd date, which they said was then the last day to register. And if you register by then, you're assured of at least being on the list that's going to be published on the day that FATCA withholding goes into effect. So as a practical matter, if you register by June 3rd, you should be fine. By the end of this year, December 31, 2014, FFIs covered by model IGA agreements don't have to provide withholding agents with a GIN with respect to payments made before January 1st, 2015. So those FFIs effectively have until the end of the year to register. I would just add that, if you don't register on time, you should still just do it, because even if you submit and even if you haven't received your GIN, I think there are provisions on the W-8 Ben-E where you can put down that it's pending. And as I'm going to mention in a moment, the IRS has adopted kind of a common sense, if you make a good faith effort to comply, then they're going to try to be lenient here. So I think the message is, as soon as practical, even if you've missed a particular deadline, you should obtain the GIN. Just going through a few other significant dates with respect to the reporting of U.S. accounts. I'm now on slide 24. Next slide. By March 31st of a particular year, FFIs are required to report information about their U.S. accounts. With respect to 1 year, you have to report by March 31st of the subsequent year. For Model 1 IGA FFIs, there will be deadlines set under local law, and then those local jurisdictions will be required to submit information to the U.S. government within 9 months of the end of the calendar year to which the information relates. And the extent of the information required to be reported is implemented in phases. So the most basic information, name, other identifying information, but account to balance, etc., they've phased it in so as to, again, attempt to make it maybe a little less burdensome. Next slide. There are also certain documentation requirements for so-called pre-existing obligations, which include obligations outstanding as of June 30 of this year, or issued or executed between June 30 and the end of this year. So in a non-IGA jurisdiction, the deadline is the end of this year to identify and classify holders of pre-existing obligations held by so-called prima facie FFIs, who are persons who have certain obvious indications of being an FFI. June 30 of next year is the deadline for banks to identify and classify holders of pre-existing individual accounts exceeding $1 million. And June 30 of 2016 is the deadline for identifying and classifying holders of all other pre-existing individual accounts. This is, again, non-IGA jurisdictions, so under the regs. In IGA jurisdictions, it's basically the same timeline, except that the IGAs extend the deadline for documenting pre-existing entity accounts held by the prima facie FFIs to June 30 of 2016. With respect to new obligations, so non-pre-existing, documentation procedures must be in place by July 1st. I think we'll go on to slide 27, because 26 is a little repetitive. So just wanted to mention, I think I have just a few more minutes left, but I wanted to mention some recent guidance. Essentially, the beginning of this year, there have been a lot of notices come and, and new proposed or temporary regs coming out from the IRS as the date for implementation approaches. For one thing, there have been some comments that they were considering another extension beyond July 1st. We haven't seen that yet, and I don't think I'd count on that. They have indicated, the IRS has indicated, as I adverted to previously, that they plan to enforce FATCA lightly during 2014 and 2015, provided that they can determine that a good faith effort has been made to comply. So, again, I think they realize this is rather burdensome, particularly the long arm of the IRS over non-U.S. institutions, and they're trying to adopt a common sense approach. In addition, recently the new forms have been issued. The IRS issued revised forms W-8-BEN for individuals, W-8-BEN-E for entities, the W-8-ECI, IMY, EXP. All of these W-8 forms have been revised to include provisions allowing people to indicate why they are FATCA compliant or FATCA exempt, for example, foreign pension plans or sovereign wealth funds. And final revised instructions to these forms have also been released, although we're still waiting for the final instructions for the Form W-8-BEN-E. It's expected these will come out before July 1st. In addition, the IRS has released final revised IRS Form 1042, which is the reporting form that you use as a withholding agent, and the instructions there. And the IRS 1042S, foreign persons U.S. source income subject to withholding, and the instructions on that, again, are expected before July 1st. Next slide, 28. In addition, with respect to IGAs, there have been a couple of pronouncements. It's been announced that countries that have not yet entered into IGAs but have been negotiating with the U.S. on them and have reached an agreement in substance will be treated as having an IGA in effect through the end of the year. And there's a list that the IRS has of such jurisdictions. So we have an example here. BVI and Hong Kong will be treated as having Model 1, Model 2, respectively. The text of IGAs that have been reached in substance will not be published until the IGA is signed. Until that point, the jurisdiction will be treated as having in effect the provisions of the Model 1 template or Model 2 template as applicable, which, as I mentioned, were released by the Treasury some time ago. And FFIs that are covered by an IGA that has been reached in substance can register with the IRS consistent with their treatment under the relevant IGA template. If a jurisdiction that's reached an IGA in substance does not end up signing up the IGA, then FFIs in that jurisdiction will be required to update their registration status accordingly, and they will have to register as a non-IGA covered FFI, under the regs. There's been, next slide, there's been some recent guidance that the IRS came out with respect to how branches and disregarded entities must report or register for FATCA. Temporary and regs have also been issued coordinating FATCA withholding with pre-existing U.S. withholding and reporting regime that applies, generally with respect to U.S. source payments. And these regs are designed to coordinate so that to ensure that you don't have double withholding under, both regimes, to remove inconsistencies between the regimes, and to ensure that payments won't be subject to FATCA withholding and backup withholding, and there's certain exemptions. The IRS announced that it will issue some clarifications of these regulations. They're not going to entertain comments on these, but they will later when they issue proposed regs prior to the regs finalized. So I think that we're just about on schedule, I hope. I think that takes us up to Joe.
Yes, you did a terrific job, and thank you so much. And please stay with us for the question and answer session that will follow. Attendees, if you've heard anything you'd like to know more about, you do have that chat window in the lower right-hand corner of your screen, which you could use at any time during the presentation today. Submit a question, and we'll get to the Q&A later. And Willis Schneider, thank you so much, and please stay with us for the Q&A, okay? Okay, very good. We're going to move on now to our next speaker, but before we do, we're going to issue the second secret word, which is FATCA. F-A-T-C-A, FATCA, is the second of the secret words today, and you want to jot that down as secret word number 2, FATCA, so you could put it in your surveys later and get your continuing education credit. FATCA is secret word number 2. All right, we're going to move along now. Joseph Riley is up next, and Joseph, you also will have your 20 to 25 minutes, means your off time should be around 58 past the hour, so please go ahead.
Well, thank you very much, Paul. So turning to slide 33, what I want to cover first is the implementation of the IGAs. So once a country has entered an intergovernmental agreement with the United States, there's a process for the FATCA effects of the agreement to go into effect. Now, an intergovernmental agreement is not a treaty, so there's no requirement in the United States for the Senate to approve the agreement. It really will go into effect with respect to the U.S. side of the agreement as soon as it's executed and signed by the representatives of the U.S. Treasury and the representatives from the other country. Now, the way it gets implemented in terms of FATCA will be that the agreement really as itself does not have an effect. What will need to happen, depending upon the legal structure in the other country, which we call here the FATCA partner country, will depend on what the laws are in that country. In many cases, they will need to have an actual new statute or other legislation enacted so that the intergovernmental agreement can actually come into force in that country. What may often be the case, which is not specifically a tax issue, but is certainly important in many of these countries, are certain privacy laws. And very often part of the enactment of the legislation will either be a direct or indirect effect on the privacy laws in that country, such that the financial institutions, the banks of that country, the other types of investment funds or other types of financial institutions that are attempting to comply with FATCA will be doing reporting, and in many cases the reporting is done to the local government. And again, either directly or indirectly, the enabling statute for the IGA will protect that financial institution from the application of the privacy laws in that country. So that's one thing that should be noted and is figured to be important, is determining exactly how the privacy laws in each of your jurisdictions for which you're responsible are affected by the potential reporting that would need to be done with respect to FATCA as it gets implemented. Now, once a statute is enacted by the FATCA partner country, very often they'll need to delineate more detail using regulations exactly how the financial institution should basically process this information. What are the deadlines? What are the details? When should things be reported? To whom should they be reported? What format should they be reported? And that is going to be very important for you as a representative of a non-U.S. bank or other financial institution to get those levels of details. In addition, there's likely going to be quite a few exceptions in terms of how the rules apply. And when I say that, many of the FATCA agreements, and certainly throughout the U.S. FATCA regulations, there's a lot of rules that allow what you might call either abbreviated reporting or simplified reporting, depending upon the type of account that's involved or depending upon the type of account holder that's involved. For instance, to the extent that your account is owned by a tax-exempt institution or is owned by perhaps the government in your jurisdiction or other types of account holders who are not the type of account holder that the U.S. FATCA rules are attempting to identify. Very often, if all of your account holders are that type of entity, you may well be eligible for a very reduced type of process in terms of how FATCA gets implemented. So there may simply be less information that you need to file with that local government. So it will be important for you in each of the jurisdictions for which you're responsible to understand exactly how those regulations work. And I think you'll find that if you're responsible for more than one jurisdiction, that very often the regulations that are implemented in these jurisdictions tend to be very similar to other jurisdictions, to other countries' regulations, and also somewhat similar to the U.S. Treasury regulations for FATCA. The very first jurisdiction to issue FATCA regulations was the United Kingdom, well over a year ago now. So as a result of that, their regulations have been a fairly good base for other jurisdictions when they're drafting their regulations. Now we have detailed regulations in also what's called guidance notes, some cases just draft guidance notes, but they're basically regulations, you might even call them instructions, but they've been adopted in a relatively informal way. The informal process allows some degree of flexibility so that to the extent that people such as the banks that you work for or work with have questions or complaints or requests for clarification, by using a guidance notes format, it's allowed some ability to amend the rules, to change definitions, to make things a little clearer as people begin to establish processes for implementing FATCA in their jurisdictions. So again, we have the United Kingdom has issued their regulations. They've actually issued regulations vis-a-vis the United States, and they've also issued regulations vis-a-vis what we call the Commonwealth Dominions, or in other words, certain countries or jurisdictions which are historically associated with the United Kingdom and have sort of their own UK-based FATCA process going into effect as well. Ireland has issued their guidance notes, and very importantly, the Cayman Islands has issued their guidance notes as well, only in the last couple of weeks. So many of you may well either have investment funds or bank branches or other types of clients that are using a Cayman Island entity or a Cayman Island branch, and so the Cayman Island guidance notes are pretty important. Now, what we're going to focus on is the issues of entities, again, the governments on your side, and then individual financial institutions about how we implement FATCA. If we go to the next slide, please, slide 34. Now, with respect to the intergovernmental agreements, one thing which could happen down the road is the possibility that a FATCA entity, although it's registered, becomes non-compliant. As representatives of these institutions, it's important for all of us to understand that there is some possibility down the road, no matter how quickly these financial institutions register, that there is some possibility that some financial institutions will simply not do the appropriate amount of paperwork and could fall out of compliance. And there's certainly a process anticipated for that in the IGAs. Generally, it requires a long lead time of notice between the jurisdiction and the U.S. Treasury as to the result that a particular financial institution is not meeting its reporting requirements. And in that case, there is an ability for that financial institution to be regarded as non-compliant. It's generally about 18 months, so obviously that's plenty of time for some type of remediation to occur, but everyone should be aware that just signing up on day one is not a lifetime of qualification under FATCA. There is a continuing obligation to maintain compliance, and there is a process for someone effectively being disqualified as a compliant financial institution. A second important point is that the IGAs all have what's called a most favored nation clause. Now, the IGAs are based upon certain models that the U.S. Treasury set up at the beginning. So there is a possibility that an IGA may differ very significantly from the original models. But in most of the cases so far, there have been variations, but not major variations. But of course, each IGA is separate, and only the terms of a particular IGA are the ones that institutions in that particular country need to worry about. But what a most favored nation clause does, it basically says, to the extent that there is a variation or significant modification from the model in other IGAs executed later, then if it's a beneficial clause, it can be actually reverse implemented into the earlier IGA. So, but it's important that the most favored nation clause does not apply to the Annex 2 of these IGAs. The IGAs always have three parts. The basic part, which is what you might call the body of the IGA, which sets forth the requirements of either side. There's Annex 1, which sets forth the due diligence procedures that are required to review your accounts. In Annex 2 is a setup of definitions, particularly that apply to certain types of entities that deserve relaxed FATCA reporting. And so the most favored nation clause affects the body of the IGA, affects Annex 1, but would not generally affect Annex 2. Now, there is a term which can be somewhat confusing. Now, when we talk in FATCA world, particularly in the U.S. Treasury regulations, we talk about participating foreign financial institutions and non-participating foreign financial institutions. One point in the IGAs is that a non-reporting financial institution, although it sounds like it's non-participating, actually means the opposite. A non-reporting financial institution is an entity that does not have to report under FATCA, and so therefore is actually in a good place, whereas a non-participating FFI is a financial institution which is responsible for FATCA reporting but is not actually doing it. So those two terms can become quite confusing. So that's why I wanted to point out the distinction. Moving on to slide 35. So account due diligence. Now the basic purpose of FATCA is a requirement that non-U.S. financial institutions review their accounts to identify and report on the U.S. persons with those accounts. So the IGA generally has a fairly detailed list of what has to get done with respect to the accounts in that jurisdiction, and that's set forth in Annex 1. If there is something that's either unclear or is different, a foreign financial institution can generally look back to the U.S. Treasury regulations as well. Normally there will not be a huge amount of variation or difference between the Treasury regulations and the IGAs, but there could well be. So that would be something that would have to be looked at. Now, the second thing would be that the IGA jurisdictions would not have to withhold on accounts to recalcitrant account holders. Now, this is one of the more important parts of the IGA, is that we don't have to withhold if we're a foreign financial institution that has either identified a U.S. person or perhaps identified a potential U.S. person, and that account holder is not being responsive to our request for information. Under basic FATCA, there may well be an obligation to either withhold in certain cases or simply to close the account and other situations. But generally, the IGAs have an exception to that rule. As I mentioned earlier in a passing reference, that there are certain privacy laws that can be affected by FATCA. This is a related issue, that in many cases in these countries, there are rules which you cannot simply close somebody's financial account. And very often, the IGA here protects the financial institution from having to either close that account or impose withholding. And so that's something that it's important to keep an eye on. Let's go into the next slide. Now, reporting. Now, I think as Willis mentioned, there's two types of IGAs, Model 1 and Model 2. In the Model 1 IGAs, the financial institution, in other words, the foreign bank, reports the U.S. account holders and their activity to the local government, to the local financial institution or regulatory authority. So, for instance, in the Cayman Islands, it's the Tax Information Agency. In the UK, it's their revenue authorities. That's Model 1. Model 2, the foreign bank reports directly to the US IRS, or the US Treasury, generally the IRS. So it's important to understand the rules that are affected in your jurisdiction. So when we're dealing with Model 2, we're going to be reporting directly into the U.S., which is the same process as occurs if there was no IGA at all. The IRS form that you'd be using is generally Form 8966, and that will be the one where you report the U.S. Account holders and their activity. For Model 1, when you're reporting to the local regulatory authorities, it will really depend upon whatever process they delineate in their regulations and potentially their guidance notes as to how and when, the format, all those details will be jurisdiction by jurisdiction. Some jurisdictions, may find Model 1 more beneficial. Some may find Model 2 beneficial. But that's usually a decision that would have been made by that government and is generally not going to be, optional for the banks that you're working with. Now, on slide 37, if we could turn to slide 37. Now, one of the things you want to focus on is withholding. As I mentioned before, generally for Model 1 and those IGAs, you're not going to have to withhold on U.S. withholdable payments, even to entities which are not participating. So in other words, you're responsible for a foreign bank. You have an account holder, that's an entity, another financial institution, and you request confirmation from them that they're FATCA compliant. They do not provide it. And so as a result, you may well need to treat them as a non-participating foreign financial institution. The IGA for you, for your jurisdiction, may well say you do not have to withhold. If there was no IGA, you may well, under FATCA, be required to do that withholding. But under the Model 1 IGA, generally you do not. So what you do is you provide to your immediate payor, in other words, that's the U.S. withholding agent or U.S. payor that you're dealing with, and you tell them, look, I have this non-participating FFI. This is the percentage of the amount of payments that you're sending to me that are applicable to them, and they may well have to withhold with respect to that part of it. But the responsibility for withholding would not be on you. Now, there is a concept of something called a QI, or qualified intermediary. That is something that may well be important to you because many foreign banks have established a process, which they're entitled to with respect to the IRS, and this is an old process going back many, many years, where the foreign bank can agree to do all of the withholding analysis, both for FATCA and for general U.S. withholding, basically in-house. And so that means that the U.S. banks, which might be sending money to you as a foreign bank, do not have to do any withholding because you're certifying as a foreign bank that you are responsible for the withholding and you will pay over to the IRS any withholding amounts that are due. That could be FATCA withholding or general U.S. withholding, but that's an established process for a qualified intermediary. It just means that your bank has taken responsibility to be effectively the withholding agent even though you're not in the U.S., even though you're outside the U.S. Most of the model IGAs, if not all of them, do have this concept that in the future there will be new rules for what we call foreign pass-through payments and for gross proceeds. These are supposed to come into effect in 2018. Gross proceeds just means withholding on the sales of positions that would generate U.S. source interest and U.S. source dividends. Right now, the FATCA withholding that we're dealing with is mostly on interest payments and dividend payments and then other sources of U.S. source income, but generally not for proceeds from sales. So proceeds from sales comes into effect in 2018. And so eventually we're going to have to deal with that. Foreign pass-through payments are payments that are not actually U.S. source, which is the category we're dealing with today, but that are, quote, attributable to U.S. source payments. An example of that would be, say, a payment from the U.S., a U.S. source dividend payment made to a non-U.S. investment fund. Then that non-U.S. investment fund, which say is a corporation, makes a payment to you in your bank, in whatever jurisdiction you're in. You might say, the payment that you received is not from the United States, it's from this Cayman corporation, so therefore it's not U.S. source. And you would be correct. And so FATCA today would not reach that payment. But this pass-through payment concept, which again is pushed off for a number of years, eventually would capture that payment and pull it into the FATCA net. But the IGAs have punted on that, so that will be an issue that will be dealt with at some point in the future. So going on to slide 38.
And before we get to that, I do have to interrupt you just for a second here. We have to get another secret word in. It's asset. A-S-S-E-T. Asset is the third secret word, and you'll want to jot that down to get your continuing education credit. Asset is secret word number 3. And Joseph, just as a reminder, you have about 3 minutes left for your portion, so please keep that in mind, okay?
Great. The next concept I just wanted to walk people through is expanded affiliated groups. This is basically a similar concept to dealing with a consolidated group for tax purposes. When you have one company that owns another company or a partnership that owns the majority of another company, then you may well have an expanded affiliated group. Generally, we're using a 50% ownership test. But one thing I want people to point out, to understand, is that there's 2 important ways an affiliated group is important here. The first one is in registering with the IRS. In the registration process, it's quite clear that you can basically subdivide your affiliated group and have individual chains in the affiliated group register. However, once you're sort of up and running, the affiliated group rules work such that if you have more than one financial institution in your expanded affiliated group, all of your financial institutions need to be participating. And if that does not happen, you potentially could end up disqualifying the other financial institutions in the expanded affiliated group. So in other words, all the financial institutions need to stay compliant in order for the group as a whole to stay compliant, if you have financial institutions. On slide 39, responsible officers. A responsible officer is effectively the person who remains to maintain the oversight over the FATCA compliance program. With respect to IGA countries, the IGA regulations in that country will specify the obligations and responsibilities of the responsible officer, and it may be that there actually is not one, but there will be some type of detail of that in the IGAs. However, when you do a registration process in itself, there will be a box that requires somebody to identify themselves at least for registration purposes only, as the responsible officer. And on page 40, just branch and disregarded entity registration. In general, if you have a branch, and what a branch means is you have an operation in a foreign country, but it's not separately incorporated. If it's separately incorporated, it would be a subsidiary. If it's not separately incorporated under tax lingo, it's generally regarded as a branch. So if you have a disregarded entity in a Model 1 IGA jurisdiction, generally it registers as itself, apart from its parent entity, even if it's not separately incorporated. And it generally works a little bit differently in the Model 2 jurisdictions. So with that, Paul, I want to turn it back to you.
And thank you very much, Joe Riley, and please stay with us for the Q&A section that will follow. And thank you so much for your comments and your input today. All right, we're going to go on to our next speaker, David Lewis, but I'd like to use this quick break to mention that the Knowledge Group also provides outsourcing services such as CLE processing for your land events and webcasts, inexpensive and professionally produced private label and custom programs, and outsourced research and business process services. All of our services have been designed to save your firm money while taking away the hassles of doing the challenging legwork. You read all about them on these slides. That would be slides 41, 42, and 43, and in the flyer that will be attached to the survey email. And thanks so much for your attention to that.